introduce each other, and we've got two new board members, I believe, Todd and Greg. Let them introduce each other as well. So we'll just start over there.
I'm Janet Booker Davis. I've been on.
I'm Andy Bonner, aka Jack Bonner. In case you hear that name, that's me. This is my second.
I'm Pam Church, and I'm starting my second term, so this is my fourth year on the board.
I'm Larry Elmore. I just recently retired from Pew CPAs in Knoxville, and I'm in the first year of my second term, so it's my fourth year.
And I'm Kevin Monroe. Welcome to the board. I also just retired from Deloitte here in June, and I'm just starting my second term on the board.
Stephen Eldridge. I'm from Jackson, Tennessee. A partner with ATA, Alexander Thompson Arnold. I'm not retired. I'd like to be, but I'm not. I'm on my 8th year, I believe, on the board. So, seven? I thought I just jumped over the threshold. Somewhere like that. I'm in my 3rd term.
I'm Gay Moon. This is my second term, 3rd year, second term on the board.
I'm Greg Gilbert. I retired May 31st from LBMC in Knoxville.
Todd Skelton from Knoxville, Chief Legal Counsel at an investment group there, previously in Governor Haslam's legal office, so it's fun to be back in state government in a different capacity, and appreciate Gabe's resignation to create this opportunity to join the board.
Trey Watkins, I've got 1 year left on the board, so I'm kind of at the end. I'm a partner at a firm in Memphis. So.
Judy Weatherby, and I am, I guess, the odd man. Well, you're not a CPA, are you? Okay, I'm the public member, although I've spent my entire career in accounting and primarily in mergers and acquisitions and on the private side. And I have no idea how long I've been on the board. I don't. I like it. I love it. So
4 years, maybe?
Is it 4? I think it might be.
Something.
It was right after, or right at the same time you came on, Gay, except I was out of town and didn't make the first meeting, I think. Something like that.
Guys, we're happy to have you here. If you have any questions, let Wendy know. She's the smart one in the group. I'll turn it over to Larry for his committee.
Yes, we'll open the committees with the licensing committee, of which I'm chairman, and we have Mr. Bonner, Ms. Church, Mr. Eldridge, and Ms. Weatherby also on that committee. We have 2 items on this committee today. This committee usually has a much bigger agenda than what we have today. For those new on the board, the licensing committee also addresses situations where people are asking for things such as extensions of time on passing the CPA exam, where you've passed parts of the exam but not all of it yet. And so sometimes they have unusual situations where they need more time. We've had people who had house fires, deaths in the family, and those kinds of things where we address specific situations. So, but today the agenda is pretty light. In fact, both situations are requests from the board itself or the administration of the board. And Wendy, I may just introduce these and then turn them over to you to explain the reasons for. The first one is a request where there really are no statutes, rules, or requirements that forms that are filled out and for purposes of the board, applications and those kinds of things, where they have to be notarized. But historically, we have had notaries on these forms. So most of them are now filled out online. And the way I understand the explanation that Wendy's staff put together here, there are boxes when you do it online where you swear and declare that you're telling the truth and that you're protecting yourselves to penalties if you're not telling the truth. But there are 98% of the applications are processed online, but we still maintain paper applications for situations where you're unwilling or unable to process those online. So there are 2 forms where the board staff is asking for continuation of having those notarization requirements. And those are the license surrender and the inactive applications. And Wendy, if I understand this correctly, one of the reasons, or the main reason you may want this to continue to be notarized is because if these forms did get filed in error or by the wrong person or by someone other than the right person asking for it, it could mean that person would have quite a bit of process to go through to get reinstated. These forms are on your iPad there. The two that we're talking about, asking for continuation of having those notarization lines on there. And Wendy, you may want to talk some more to this. I don't know.
Covered it pretty well, and unless there are questions. Basically, the department has determined, or the Division of Regulatory Boards has basically asked us to remove notarization in all areas where there wasn't a requirement statutorily or in rules. But these two I kind of stopped and paused at because of the ramifications to the licensee if, in fact, somebody filed it on your behalf and you weren't aware of it, or something happened. It would be awfully difficult to prove whether you did or didn't file it without the notary. So I think I'm just trying to safeguard the licensee in a situation where it could be difficult for them to maintain active status again.
Need a motion to recommend this to be done, or is?
Yes, I've been advised that they need board approval for me to leave it on the form.
Can I ask a question?
Sure.
I'm not on the committee. Just, are you telling me that we allow people to do this electronically and paper, these two forms, or not? I don't know the procedural part of that.
So 98% of the applications are filed online, but we have a few people who just can't or won't go online to do it. So we still get a few paper applications. So yeah, we are maintaining the option for a paper
So
application.
electronic, you would not have this requirement.
Correct. However, you do have to log into your account. So there's that set of, I guess, a wall that you got to get past. You got to be able to log in, and then you would attest to the fact that, you know, you're not lying and you are the person you say you are.
How many applications is that a year? I mean, just how many of these forms do y'all receive?
For these, I mean, I'm really totally
2%, so that's gotta be-
totally guessing at 50 to 100.
Okay.
I mean, in totality, probably not in paper, not that many.
That's my other question. I had the same question as Trey did. Have we had any people have had an issue where they've gone online and they've?
Actually had someone just recently who the license status was changed online, but he claims he didn't do it.
But you got to have a username and a password to get in to do it.
Right. So we had to do quite a bit of research, the best we could, to try to determine, did he do it? Did someone else do it? We really weren't able to determine that. So it actually happened online when I thought it wouldn't happen that way, but I thought it would be more likely to happen from in a paper form where, you know, your ex-wife is angry with you or something. I don't know.
He probably already has the passwords, by the way.
Probably.
So they wouldn't have to upload a paper notarized?
No, they do
part of the
not.
application?
No.
Have we researched any other ways to have it online so that you can do it, but also have a safeguard that we have to send a confirmation email and then they have to input some numbers, or they have to go back online to confirm with that code or something to verify that it's them?
No. They do get a follow-up email confirming, and this previous person that I mentioned claims to have not received that particular email.
The only problem you've had is with the online version, not the paper copy.
Right. And actually, when I put this on your agenda was before I had that other issue.
Right.
So I had this ready to go fairly soon after the last board meeting, and then we had the issue with the online application. So
When you know, I haven't gone through the process online to apply for the CPA, but you don't have to send anything in that process, do you, to verify, or is it all done online now?
apply for an initial license.
That's not what this is for,
This
right?
is
No,
not-
but I'm just curious
Yeah.
how paperless we are.
Well, you would do everything online. And then we get all of your candidate file from NASBA, which we get electronic as well.
I think it would be good, set this issue aside. I think what Andy just asked about would be a good idea. If you're applying for something this drastic, like go inactive or what the other one was, license surrender, is for that person, even when they're doing it online, if they would be sent an email that said, you have requested to go inactive, can you please verify that you did something, they would have to reply back to that went
You
to
may have to call.
But if I'm jacking around with your account, I'm going to put a different email address, and it's going to go to that. That's
Oh,
all
it
I'm
would go back to your original email address.
from what we have on file.
Yeah. Go back to what we have on file as opposed to what they put in, just as a confirmation.
I don't have a problem with that.
I think
That's
it's
not-
weird that we're going to do it for one and not the other. Like, we've got 98%. We're not, it's just a little check the box. I get that you got to log into an account, but I don't know. Somebody's really got to be desperate to go and try to jack with somebody's license, I would think, by
Like the
mailing
last
it
thing
in.
I'd do, just egg their house before I do that.
So, Trey, are you saying that
Just saying, it seems odd to me that we're going to make people continue to get the notarization when other people don't technically have to do it.
okay? Well, and
But that's just my thoughts.
If that's how if that's how the board feels, that's fine. I was just a bit concerned about how easy it would be.
I mean, y'all may feel different. I don't know.
One question from a little bit of a different direction. From when we get into the disciplinary reports, that we process every meeting, we have folks that are practicing on an inactive license. And then I suspect we have folks that decide to go inactive intellectually and then just don't really go through with the paperwork, to go inactive.
Right.
And I guess my concern with having a notarization requirement to go inactive is that placing a hurdle or a barrier from people who we want to go inactive and making it harder for them to do it. Now, maybe most of them are doing it online, but I don't want to really discourage somebody. I do understand that the consequences of falsely or inaccurately going inactive are tough to remedy. So I'm torn on that one.
I can go either way. I think this is more of a procedural, operational decision. If that's something y'all feel strongly one way or the other, I have no problem going with the way that y'all, however you want to do it. I see both sides, but I think it's kind of a small issue, in my opinion. If it's easier for y'all to do it one way or the other, it's going to make your job easier than do it that way.
I can actually tell you that in Florida, if you can go online, you elect it to go inactive or to cancel your certificate. And in that case, I didn't realize you had to get a notarized copy. And I got an email, I guess it was about 2 weeks later, that said, hey, did you send in your notarized copy? We haven't received it. And I was like, what? Of course, you can't call them. You can't get them on the phone. So it took me a while to research it. And sure enough, it was there, and I had to go back and print it and then go get it notarized and then send it in. I thought, well, that's kind of a pain, but maybe that's what other states do. I would say that, do you know how many other states require the form versus just electing it online? Or
I do not. I would say that we are a little ahead of the game with the number of folks that are doing things online or even having the capability of doing what we do online. I would say we're in the upper half for sure.
I guess my reservation is that that's the way most people are going, is to try to do everything online. So, but at the same time, I understand what you're saying, because that could be a heartache for someone. But
Is it really that? This is me asking the question because I really don't know. But is it that big of a problem? Have we ever had incidents like this in the past? And then what goes into fixing the problem once they say, hey, wait a minute, that wasn't me?
I think that the problem comes is that when you have people verbally just say it wasn't me, I didn't mean to do that. I didn't mean to go inactive, because we've definitely had that before.
But a notary's not going to stop that.
No, true.
Right.
But when we aren't in the position of being able to listen to someone's story and then subjectively decide whether that's accurate or not. We live our life a little bit more robotically, where we have laws and rules, and it either fits there or So this doesn't have to be lengthy. I was a little bit concerned. Basically, the department asked us to take them off, and I was just a bit concerned about these two particular applications. If y'all don't have a concern about it, then I'm happy to just go along with the way we're doing everything else.
Do you think if there were a confirmation email that went back to the
There's always a confirmation email that goes back to them, but as in this other situation, which I know isn't really it was an online application. He says he didn't get it, he never went online, he didn't log in, he didn't change his status, so either he forgot or he had someone in his office do it for him, but it became very hard for us to tell what the truth was, and we can't just reverse things because someone said, I didn't mean to do that. Or
if it's notarized, and that's your evidence that you should have known.
Yeah.
Would it be possible, just a version of what Andy said earlier, to have a proactive response to the email that, I don't know how possible it is, but anyone who inactivates or does something like that online, if we sent an email and said, please confirm your request to do this, and then to that email, to the email address we have on file, and then we have to get a response back before we do it. That would be, to me, as good as a notary or anything else. This is what you're about to do, and
meaning to the email address that we have on file.
Yep, and
not
that way,
whatever email address it may
that
have
way
come
the person is like taking another action from the original email address and is confirming what we're about to do, and then we have record of that in the file or whatever, or electronically.
You also have a read receipt on their email.
read
when you send it or
receipt,
something.
whatever.
Just anything that would say, hey, they opened it.
We have them reprogram that to be able to do.
That's.
I know. I know
sounds
that's
easy
difficult.
and all.
It sounds. I know, and
I
that's
like
why
it,
I'm saying,
but-
would it be possible?
What about this? What would y'all think if we just said, hey, let's go ahead and have the notary, but at the same time encourage the staff to seek out maybe new technologies, whereas we could possibly text a number if we could have, design the software so a number can go to their cell phone via text, and then they can put that number in and then confirm it.
Or we're making a much bigger deal out of this than it should be.
I agree with that.
And so I think what I would be doing is figuring out, is this really going to be a problem? Have we had these kinds of problems? I understand when a problem happens, it may not be totally easy to deal with at that moment in time. But at a minimum, maybe when you do the confirmation email, you have a read receipt or something you can just stick in a file. Say, hey, somebody opened it. It was the email we had on file. I hate for you to go create some whole system for something that's not really an issue.
I guess what we're finding out at the bank is that emails going to somebody don't really mean anything.
I agree,
And
but again-
electronically, you can be stolen or hacked at any time, and they've got your sign on them.
If somebody really wants to
password
go
and
through the
everything
whole
else.
thing, though, too, with that, they can find a notary probably to sign off on it.
Yeah.
That's just the reality.
But if they had
If I'm
somebody
committing
else
a
to fill-
fraud.
like if they had
Yeah,
their
I'll go. Yeah, it's easy.
administrative person do
Black
the
market notary.
application, it's probably going to come back to that same person anyway, so.
But I kind of think what the world's going to is some kind of electronic digital number to your phone, and then you confirm it in that that's your phone because you've had the cell phone number in there. And I pretty much bet we don't have anything close to that right now.
Oh, just like a two-factor authentication is what you're
Right.
Right.
referring to.
So
Yeah.
I really do think that that's what we're going to. So maybe this is just to stay with the same one, because I know other states are still getting the signature too and the notary.
I would make the motion to recommend to the board that we we use the notary for these two forms, and then, like you said, we explore other options if there's programming ability or whatever that cost is to get it updated to some kind of email confirmation or two-factor authentication or whatever, maybe a blood sample or something like that, or DNA test, just to be sure. There's my motion.
I'll second it.
This motion and second and vote that we're getting ready to take is a motion to recommend tomorrow in the board meeting to that effect, so it doesn't happen until tomorrow. So we have a motion and a second. All those in favor, aye? Aye. Any opposed? Okay. We'll make that motion. second item on the agenda for the licensing committee is, here again, this is kind of an administrative thing. More and more, what we're finding is that more and more courses are being folded into the accounting agenda, accounting curriculum at universities and so forth. And so the situation has risen here where we have a course at ETSU. It's actually called Information Technology for Accounting. And the question is, does it meet the accounting education requirement for licensing and for taking the CPA exam or receiving a certificate? And so we have here 2 or 3 pages of information about this course. The argument for approving this course as an accounting course from this applicant is that even though it is an Excel course, it's teaching the student how to use Excel in applying it to accounting applications. And so if you look at, for example, the description and the activities that the class has, it's the last 2 pages on your iPad there. It shows like the dates that certain things are due and the accounting applications. And so there's things like multi-step income statement, depreciation schedules, bank rec, cash flow statement, LIFO, FIFO calculations, and so forth. So although the course is described in the syllabus as an Excel course and it's actually titled Excel or Information Technology for Accounting, this applicant's argument is that it's using accounting applications with the Excel spreadsheet. So it, in effect, furthers their ability to perform accounting applications by using the Excel means of doing that. So the question before the committee is, does that meet the requirements for accounting education, which the rule is that at least 30 semester or 45 quarter hours must be in accounting education. So, anything to add to that, the question?
No, except for just to keep in mind, sometimes we get general Excel courses, and we have been reluctant to approve those in the past. So with your discussion, maybe some comments on, if you approve this, are there parameters that we can consider when looking at other courses?
And it is we're going to see more and more of this, I think, because more and more schools are introducing classes, not only Excel or computer related, but also just general people skills and footnote writing skills and those kinds of things that we're going to be asked to address. And so it is something that we need to think about very seriously as to what effect it may have on future requests.
We need to require basic grammar, to be honest with you, for the curriculum. I'm being serious. When you said you have other Excel, people apply for other Excel courses that are not accounting related, whether it's just a general, I mean, is there a difference? Like I took accounting information system. This is about what that is.
So a lot of times there are Excel courses that aren't in the accounting umbrella, so they're general Excel courses. And so without them being under the accounting arm specifically, I don't think those have been approved in the past. Now, there have been courses that are under the accounting umbrella that are technology driven that have been approved, but they're accounting specific.
I don't have a problem with this course. Mm-hmm. It's just how do you differentiate, even though, honestly, most of these topics that are in this curriculum people don't use. I mean, people don't use Excel for payroll, and I mean, it's just different programs like in private, in public accounting. But I have no issue. It's just how do we differentiate what's an accounting class versus what's a basic Excel skills.
I'd like to hear Pam's take on this topic. So we're all going to listen to you for a while.
Good. Let me impart wisdom.
Yes, please.
Well, we started this discussion last time with the course, the auditing course, that was using technology. And all of us, I think, were in favor of approving that because it was applying technology to auditing, which is the way auditing is done. It seems to me there's a continuum, and we're going to have to deal with that gray area at some point. So the problem, to me, is not the Excel course that's in a department of a computer department. It's a pure Excel course that's accounting 202. So what are we going to do with that? I mean, I'm with you. This is systems. I mean, systems courses vary so much from school to school, and maybe that used to be even more true. But you say accounting systems, and it's just all over the charts. It's just the flow of data, and you just pick what you're going to teach. So surely we will not turn down courses because they use too much technology. But the question is it based in accounting? And I think we're going to have to make the difficult decision of saying yes or no. Does just an Excel course count, regardless of where it is? Because this is what the AICPA is dealing with as far as certification. They want to make technological experts their education substitute for accounting. And so it's really tough to come down on this and say yes it is or no it's not.
What we learned last week at the board meeting was that with the CPA evolution, that this is really going to change the definition of what is considered your core courses / your extra 30. It won't be the title of the course anymore. It'll be what's taught in the course. They want us to look through the title. And the reason for that is because when you get into some of the schools, they're actually sending their accounting students over to data analytics or data processing, IT, to actually learn how to gather the data with the new technologies that are coming out and bringing it in and then sorting it to put it into financial statements. And we got into a conversation Friday about this, and they were talking about that, they're going to the Education Committee and saying, define what you think needs to be in a new education format for students now. And secondly, then looking at the CPA exam to say, how does that apply to what the exam is telling us and what you're taking on the exam? And then thirdly, we have the core principles that are out from draft, the 5 core principles. And in that, there's a suggestion, there's not a 2 pathway anymore, but there's a suggestion that if you look at people who are non-professionals who are working with the big firms right now that do not have their CPA, that they're actually, they know more about the data and how to get the data and how to sort the data because of their education from the IT side. But they, what they've got to come up to speed on is the financial statement side and the insertions and so forth. And so I think we're going to have a lot more of this in front of us in the future. It's something that they're actually going to ask the Uniform Accountancy Act to be updated for it. That was one of the conversations too. So in this particular case, I feel like this is a great course and it can be applied. A basic intro to Excel, I'm not sure that really is it. But, maybe there's I know there's a new program out. I can't remember the name of it. They said that's like the big thing in the big 4 firms that they're using to sort data with.
Well, there's Tableau, Power BI.
Tableau.
Okay. Yeah.
And that, if somebody had a Tableau course, I've never used it before. I understand that everybody's using that to sort data with, which would be a great course for accountants coming into the field to get a head start. So I think we're going to have more of this, but I'm very much in favor of this course.
I don't think that we're going to be able to come up with a one answer or one phrase requirement that says this will meet the requirement, this one. I think it's going to be an individual decision.
Based on content.
Yeah, and I'm like Andy. I think this is a good course. The one thing I like about this course that I think would sort of differentiate it from others that would just be purely Excel was this is kind of teaching you how to use Excel to apply into the accounting world and how to apply the applications of Excel into things that help you work your accounting situations better. In other words, using Excel to accomplish accounting skills or requirements. So I would recommend that we approve this one. But as far as the second question, about parameters to establish other courses, that one's the tougher part of this question. I don't know that,
My only thought on that would be is to put a limitation on what would count for the hour requirement, maybe. I don't know if it's one course or two courses, but I mean, Excel in general is a good thing.
limit the number of hours you can
So
get
if
in.
you did want to do that, if somebody wanted to make a special request for something additional, maybe they could come before the board, or we're just going to let you count 3-hour class or whatever it is.
The whole profession's grappling with this, so it's not an easy situation. But so far, I'm not willing to say that I'm ready to substitute data analytics for accounting and auditing.
I would agree with you in substitution.
Just like finance you need finance. We have finance experts working for Big Four CPA firms. We have valuation experts working for CPA firms. But those aren't substitutes for accounting. So we have and other business courses, 24 credits. In my opinion, pure technology courses still belong there, but
Let me say this, I don't believe in the 150-hour requirement to begin with, so I'm thinking, how can I get there a different way?
We know.
So, but my point is, everything I do in my firm touches Excel,
Oh, yeah.
period. So
Yes, yes.
any coursework that allows that person to come in and do things that, quite frankly, I don't know how to do, I think is a good thing. But
I don't know how you change or you go ahead and approve things in advance, because the profession is constantly evolving. And, you know, something tomorrow may be on the shelf that says you have to have that to audit, especially if all your data's in the cloud.
Well, to Stephen's point a while ago, about the writing skills, if we were looking at a course that was on writing skills, and it was how to write a footnote on pension disclosures, how to write a footnote on other excused absences or whatever, we would probably qualify that. So why not qualify a course that takes Excel and applies it how to apply Excel to accounting? So, I mean,
Vanderbilt has an accounting communications course. Do you know how we classify it?
A lot of times, for so many students, it doesn't come down to one course. So they may have taken it, but they didn't actually need it to qualify. So this,
If they have a master's, that's true, but if they're just doing the 150, that's probably not true.
right, or if you're a non-traditional student where
Yes,
your degree
absolutely.
was not in accounting and you're just trying to piece together enough hours to meet the requirement, is where we typically find this.
Well, I hope we track what we say so that we're consistent, because the more of these situations we consider, the more we're building a decision tree, right? So this one, I think there's no question.
and I have a feeling that NASBA will set a precedent for us in some cases and have some parameters that they're going to approve or recommend.
Working on that now.
I make a motion that we approve this particular course.
Can I-
think it.
Can I ask
Oh,
one
yeah, yeah,
question? I'm assuming she's not asking for upper level accounting hours.
Oh, it would definitely be upper
Well,
level.
It would be?
Or that's what she's
That's
requesting.
what she's wanting?
Yeah.
Okay.
Yeah.
It has prerequisites.
Yeah.
And I'm not, Pam, I'm not sure, is this course level, is this an upper level? I don't know what.
Accounting systems is,
That's
would say,
okay.
almost always an upper level.
It's a 3,000 level course, which is typically considered a junior level course, 300 or 3,000.
They had to have studied these topics before they get to this point.
I'll second it.
Okay, we have a motion and a second. All those in favor, aye?
Aye.
Any opposed? Motion carries. Those two relatively simple items on the agenda took a little longer than I thought, but that's all our committee has today.
Right, next on the agenda is the Enforcement Committee.
Okey-doke. Thanks, Wendy and Stephen. Thank you. We have two elements in the Enforcement Committee. We've got an overview in the read-ahead packet, just the complaints open and closed by month for the quarter. That is a standard report that the board receives with respect to this. And then we have a number of individual, what I'll call case numbers, that we will need to proceed as a committee to adjudicate and determine, and then we'll be recommending board action on these cases tomorrow, where the entire board will vote on And one thing, working with Wendy and the team, thank you for kind of preparing this synopsis of the cases that we have here to go with the agenda to kind of help us follow through and just at a very high level synopsize what we're dealing with. I think that'll be helpful going forward. So appreciate the staff work that went into that. What we have traditionally done is we have kind of three types of cases, and Gabe, who is the chair before his elevation here to head of TennCare, broke things down to the consent agenda, where we have cases that are generally less complicated, more cut and dried, and basically fall out in a way that we can render some consistent judgments. Then we have the proposed discipline for the unique cases, and then occasionally there will be a representation of a case that was previously brought before the board now that we have further information that we'll have to basically adjudicate. So for the consent items, which are cases numbers 1 through 10, if we kind of look at the summary here, most of the recommendations here are either close or letter of warning. And in many cases, there was no evidence supporting the allegations. It's not that we didn't look for that evidence. There was follow-up done on the part of the staff of the Board of Accountancy, and they were unable to substantiate the allegations that were made. And so where they do that, they report back that recommendation and they recommend closing it. And so I won't go through each of these first 10 items on the consent agenda in detail. There is one, I think, case number 3 that, as I understand it, Janet will need to recuse herself on, so we'll deal with that one separately. But other than that, are there any questions on any of the items in the consent agenda, case numbers 1 through 10?
On number 9, I wasn't clear on exactly what the issues were in that one. Is somebody able to?
Basically, the granddaughter was kind of interfering with the CPA and the client and wanting certain information, and the CPA, the respondent, was not willing to give that to the granddaughter.
And that was on the basis that the granddaughter was not the client of the,
Right, the granddaughter,
respondent CPA.
The granddaughter was the granddaughter of the client.
Yeah.
Yeah.
A question about number 4. The question is, was there any prior history with this respondent, or we've ever had issues with them before? It says NA on the history, so I didn't know if that meant no or.
There's no history, especially in the last 5 years. I think we go back 5 years.
Other questions on cases 1 through 10 in the consent agenda?
Question on number 3, was the leasing company contacted for their perspective on why application of funds funds were withdrawn for different tenants and the mistake there, or is it just based on the respondent?
I investigated that. No, we did not contact the leasing company directly, but there was a tremendous amount of email communication back and forth between the respondent and the people at the leasing company, and from that it was clear that it was a misunderstanding.
Great, thanks.
Mm-hmm.
My only other question on 7, not necessarily about the complaint, but just a comment in there. If the Securities Division or other board is investigating, is this a formal action that we ask for referral, or is that just kind of a understanding between the reg boards within DCI?
There is a formal investigation with the financial services investigation. They asked us to look into it, and so I If they find an issue, we ask at the end if
If they find an issue acted in a fraudulent or unethical manner after completing the review, encourage them to refer the matter back to the board. Is that a formal process, or is that just kind of an understanding between the boards and DCI?
More of an understanding.
Okay.
Yeah.
Thanks.
Any other comments or questions on the consent agenda items cases? Not, what I would do is offer a motion that the committee recommend for board approval the recommended dispositions in cases 1 and 2 and cases 4 through 10. We'll deal with case 3 separately so that Janet can appropriately recuse herself. Is there a second with respect to that motion? Okay. Any other further comments or discussions? If not, all in favor of that resolution signify by saying aye.
Aye.
Aye. Any opposed? Okay. Then we'll take case number 3 separately and would offer a motion to approve the recommended outcome here, which is to close that case on the basis of no evidence supporting allegations. Is there a second?
Second.
You have a second. Is there any further discussion or comment? All those in favor say aye. Aye. Any opposed say nay. And any abstentions? We'll let the record show that Janet is abstaining on that one. Okay, we'll go now to the second category of the legal reports, and this would be in the category of proposed discipline, beginning in case 11. And these are cases where the board staff is recommending, some level of discipline against a practitioner, generally speaking. And so in case 11, we actually had basically 3 potential violations that were investigated. It was determined that 2 of those potential violations were not supported with respect to evidence that would proceed, that would support going forward. However, the third item, I believe, was in the case where they were holding out as a CPA based on an inactive license. And so for that one, that was found to have support. And the recommended discipline there is a civil penalty authorized for $500 for utilizing the CPA designation without a valid license in Tennessee or reciprocity through another state. Are there any comments or questions with respect to this one? One thing by way of background, particularly for our new membership, the board has, with the staff's help, gradually refined and attempted to make more consistent our disciplinary recommendations for as we get a little further on when we talk about issuing reports when you were subject to peer review but were not actively enrolled. Report, we kind of have a table of discipline that recommends one level of civil penalty. If you've issued 1 or more audit reports, that's deemed to be a higher level of civil penalty recommended. And so the staff attempts to kind of follow those board approved parameters, and the board, I guess 2 or 3 years ago, I think, with the leadership of Ray and others, really tried to work hard and gave as well to kind of make those as consistent as we reasonably could, but still allowing for facts and circumstances to proceed. Any questions or comments with respect to case number 11?
I have a question. We say that we're doing a $500 penalty based on mitigating circumstances and full cooperation, but and that's right, he was intentionally holding himself out as a CPA on an inactive license. So why are we saying we're going to hold back?
Well, when we ask people to get rid of the designation, it will be on websites, it may be on their signature, on email, and if they immediately do that, then that's a mitigating factor. And then a lot of people just won't do it. They feel like, I'm a CPA, so I'm going to tell everybody I'm a CPA. But they may not be registered or licensed in the other state. So,
and as long as once they're caught, they go along with us, it's mitigating? I mean, but he intentionally did it.
Well,
he knew he was doing it. It's not like he
It seems that he thought it was an oversight. I mean, I know
I can add a little bit to that.
she could probably add because she talked to him. So.
Yeah, one of the primary instance that was brought up by the complainant was on an invoice template, and he had been active at one time and had forgotten to put the inactive on an invoice template. And as soon as that was brought to his attention, he took care of it immediately. And he has limited. It's a situation where he's not providing any attest work at all. The respondent is providing accounting services only, and basically they do very little of that. He very rarely uses that invoice. So it really seemed as if it was an oversight, and then as soon as that was brought to the individual had actually made the change before I actually investigated
It
it.
says invoice template, email signature, and LinkedIn page.
Yes.
So this says there was more than just the invoice.
Yeah, it was on the email as well. But again, I think for us, primarily, some of those changes had been made before I even investigated. So I wouldn't say that's proactive, but again, if the board feels that the full penalty should be assessed, then obviously, that's fine. But we try to, based on previous guidance, if there's been some cooperation, to recommend something lower, but obviously that's your all's decision.
What would the full penalty be?
$1,000.
Yes, is that right?
Yes.
I mean, if he had it on his email signature, he sees that every time he sends an email.
What about the disputed ownership and failure to provide the records? That just seemed, what did that mean?
The failure to provide records, the complainant was asking for particular accounting records. The complainant was not a client. It was an individual in litigation with the client, and they filed a complaint saying we asked him for records and he didn't give them to us, but the complainant was not a client in any form or fashion. So that's why that would have been outside. I mean, it was within his with client confidentiality rules, without permission from the client.
This says the complainant was the wife of one of the alleged owners.
Yes, but it has not been determined at this point. There is a dispute whether that alleged owner is truly an owner. It's in litigation at this point.
When did the license go inactive?
I'll have to look that up, but I can do that.
Question as a follow-up to my comments, I think if it was on his email signature and every time he sent an email it was going out to somebody as a CPA, I think that deserves more than a $500 slap on the wrist.
Did he take it down after this office contacted him?
In terms of the template, that was taken down before we contacted the individual. I believe perhaps the email was after I contacted.
Out that software now for a couple of years has had where you can uncheck the signature background when you initially set it up. That's what we do also. We don't.
There's a difference when a license goes inactive for 6 months versus 6 years.
Yeah, so I think
That's
Trey's
what I'm
question
curious
is
about.
a good question.
Technical here, but if he sends an email and that person replies back to him and it's got his email attached to it, his signature's going to be there. And somebody's going to see it. I don't know how you go 6 years with emails going out.
She was checking too.
Yeah, I'm trying to check that out.
I just didn't understand what the mitigating circumstances were. I didn't see any.
Looks like it had been inactive for 2 years.
Further discussion, it looks like there's at least some sentiment to replace the recommended penalty with the what we'll call the standard $1,000 penalty for this type of an infraction. So for the members of the committee, any kind of sense or consensus on that?
I would, because I don't see the mitigating circumstances that we're talking about. I don't know what they'd be.
Can I ask one question just for my help in terms of this type of situation? This is a case where somebody was active, went inactive, and it was, and I agree, it should have been taken care of. But what if, like the very next one we're looking at, the person never was a CPA? Is there some way we should differentiate between those two, or is it in the board's mind the same thing?
It's not the same thing to me.
I think there might have been an attempt with this to do, something along those lines, because the second individual has never been an active CPA in any state.
There again, you could argue that if he was a CPA at one time, he should be that much more aware of the rules, as opposed to the person who never was. So
Are we saying that you're saying what's the difference between someone that never had a CPA and holds themselves out to be a CPA? I mean, to me, that's just pure fraudulent, because damn good well you're not a CPA.
I was going to say, with number 12, the individual was what you call, was licensed in another state that has a registration type licensing, or did, which meant that you could use the designation as soon as you passed the CPA exam in another state. Yet the individual was using the CPA designation in Tennessee, where that would not be permitted. And quite honestly, in this particular case, even the registration in the other state had been expired since 2009.
I would personally agree that that's a more serious infraction than the one in number 11.
And the only reason I bring that up is if if you consider upping that to 1,000, then you might also want to take some consideration in number 12 to say, does that deserve more, the same, or whatever? It's the only reason I bring it up.
Very good point.
Is there a range on this type of infraction that we have done in the past?
Well, to be consistent with the discipline matrix, it's up to the first offense is up to 1,000 with mitigating factors.
So 11 and 12 would be the same under that rule?
Yes.
Or under those guidelines?
Yes.
I make the suggestion that we do $750 on the first one and $1,000 on the second one, or consider that. So it's not, because it's somewhere in between those.
I'm not on this committee, so this is purely opinion. You go 2 years with CPA on your email or LinkedIn, that's a long time to be doing that. I mean, that's a little more than oversight on my part. So I would agree with you that it's a pretty serious violation in my mind. The rest of us are taking all the CPA. I mean, we're taking all our CPE and everything else to maintain our designation. I just don't think it's right. That's my personal opinion.
I don't know. I don't think we should be talking about two different cases at the same time, but if we're just talking about number 11, I think it should be $1,000.
Comments from members of the committee on their preferences with respect to the assessment for civil penalty in case number 11?
I don't disagree that $1,000 would be reasonable for number 11 and number 12 as well. Because, and I think to be consistent, I think it is useful to look at both of these just for consistency purposes.
At least a potential consensus on the part of the committee that leans toward $1,000, so I'll make that a motion, and then yes, absolutely, Steve.
says that he hasn't been cooperative. Has he done everything he needs to do now? I mean, what would his, give me, I mean, what did that mean? He just drug his feet, or?
Are we still talking about number
12.
11?
I'm sorry, number 12.
Number 12, none of the designations have been taken down as of this morning, and
That's
there
a
has
pretty
been no
dang good
effort
deal,
to get, there's been no effort to get the license current in the other state.
When we get to that one, we should be able to, I mean, we can charge up to $1,000 per day per violation, if I'm not mistaken. I mean, not that we would do that. I'm just saying, by law, by our rules and regulations, we can do that.
Like still running, too. I mean,
Yeah.
I think it's
that's what I'm saying.
unfair to consider 11 in light of 12 because we consider these types of cases at every meeting. And so I think we need to finish 11 and then move to 12 fully.
Let's put a motion out then on 11 and address that one, and then we'll proceed to 12. Given the discussion that I've heard, I would offer a motion to recommend that the board authorize a civil penalty in the amount of $1,000 for utilizing the designation of CPA without a valid license in Tennessee or reciprocity through another state. And that will modify the staff's recommendation from $500 to $1,000 in the case number 11.
I'll second that motion.
We have a motion and a second for a $1,000 civil penalty here on case 11. Is there any further comment or discussion?
Evan, before you vote, just for the record, the complaint number we have listed on the legal report is inaccurate, so I will read off the correct case number.
Okay.
It's 2019-01309.
Let's get that. 2019-01309 is the actual formal complaint number that is associated with case number 11 in our packet. Is that right? But the underlying substance of the case
Correct.
is the same. Okay.
Correct.
Thank you for that correction, Wendy. Is there any further discussion on case number 11? We'll go ahead and proceed with a committee vote for that case. All those in favor of the seconded motion for the $1,000 civil penalty signify by saying aye. Aye. Any opposed? Any abstentions? Okay. So that will be a recommendation that will then go to the board for case number 11.
One correction. I think I'm seconded that motion, and I'm not on your committee.
Okay. All right. Let's see. Let's make sure here.
Last time.
All right. Thank you for catching that, Larry.
I'd be happy to second.
Okay. We have a second from Pam.
When you said those of you on the committee will vote, I went,
I do that too.
sorry.
Okay. Thanks, Larry. All right. We'll proceed to case number 12 now and discuss that in its own light. And here, as previously discussed, we have an anonymous complaint, but it was investigated. And the indication was that his registration as a CPA in Illinois expired in 2009. He was never a licensee in Tennessee and has been unresponsive with respect to the follow-up that the staff has done. There were a number of other statements here, and it looks like he's finally removed his CPA designation on LinkedIn, but he's not been cooperative in removing his CPA designation in the company's website and or his resume or bio found on LinkedIn, and that's still through the current point in time.
Yes, I checked this morning.
Okay. So here the staff recommendation is for an assessment of authorization of a civil penalty in the amount of $1,000 for using the designation of CPA without a valid license. So we'll leave it there and open that up for committee discussion.
We've been strict with people who do have a license in another state but don't get a license in Tennessee. So to me, we can start there. We have not been real lenient on those people because we've said we have our rules, you've got to comply with them. This goes beyond that perhaps, but the fact remains we deal with people who don't have Tennessee licenses all the time. And we can talk about the fact that he hasn't been cooperative. To me, that's a sort of a different consideration. Mm-hmm. But I think we need to start with what is the situation. I mean, It's unique because Illinois has that two-tier system. I imagine he understood that, but still, they do let you use the CPA. But we have not been lenient on people who just don't get the license in Tennessee.
I think the penalty is far too low, personally. Just looking at it and based on what we've had in the past, I think we dole out that $1,000 penalty for small infractions, and to me this is pretty severe, especially since the guy's not cooperating at all and just seems to think that it's not a big deal, apparently.
Is it fair to say that he hasn't been registered anywhere then since 2009?
Yes, it is.
Okay.
He's not even registered, but he was never licensed.
Right.
Never licensed in the state of Illinois.
Or-
And Illinois no longer allows that registration tier as well at this point.
It's his responsibility to keep up with both states, really.
So what's the range that we could go?
Well, one thing I need to add is that he lives in Georgia, but his business is in Tennessee, and it's on the website.
I think it was an anonymous complaint. Yeah.
It was an anonymous complaint.
And he did live in Tennessee, I think, through the end of 2018, if I'm recalling correct.
Right, he was in Tennessee, but I believe he's moved at the end of 2018. He moved to Georgia.
Come into Tennessee and hold himself out to be a CPA today.
His business is in Tennessee, and there's on the company website, he holds out as a CPA on that company website. We also found something, it was a couple of years ago, but he provided a seminar in the Chattanooga area, and with the advertisement for that seminar, he held out as a CPA at that point too, in 2017.
Any questions, any more additional questions about the facts, and then maybe we can get down to the appropriateness of a penalty recommendation here.
Obviously, he's there kind of on that border. That's what it sounds like. So that means he could have clients in Georgia as well as Tennessee. Is that a fair statement?
Absolutely. I mean, considering the fact that the business is more like a consulting type thing, theoretically he could have business anywhere.
My question is, do we notify Georgia State Board in this situation, or how does that work?
When the case is closed is when we notify that if we look up to see if they're licensed anywhere else, and we notify that other state. Now, in this situation,
This
he's
person's not
licensed.
licensed. So my question
Right.
is, well, you could potentially have unauthorized activity in Georgia
We
as well as
can,
Tennessee,
so
right?
I'm glad you brought that up. We can make a note and let them know.
Due to the proximity. I mean, they're
Well, and there's also, it's worth mentioning here that he's a registered CPA in Illinois, but he's not a licensed CPA in Illinois.
He's not registered anymore.
Well, he was.
Yes,
I mean,
he
it
was.
says that he was a registered, but he's never applied
Expired
for,
in 2009.
never applied for full licensure anywhere, has he? So to say he's a CPA anywhere
lying.
is not true.
right.
Oh, keep in mind though, Illinois, for a while, and may even still have some of these registered CPAs, and they do have some provisions to allow for the use
Say
of the
they are.
designation
Okay.
in their state in certain circumstances. I don't have the details of that, but
And to go back to answer your question, it's up to $1,000 per day.
What I would do is offer a motion to authorize a civil penalty in the amount of $1,500 for using the designation of CPA without a valid license in Tennessee or reciprocity here for case number 12. Is there a second? And then we'll discuss and see where we land. Okay, we have a second. Any further discussion with respect to that from either the committee members or the board in general? Yes, it's to authorize a civil penalty in the amount of $1,500 for using the designation of a CPA without a valid license in Tennessee or reciprocity through another state.
think that seems, I mean, I just think that seems very low, given what, I mean, this is just, as Trey said, this is just fraudulent and just in our face, not complying with anything. I mean, I think this should affect his pocketbook. I mean, and get his attention, because I don't think we've gotten his attention, have we, yet? He's not doing it.
He's basically giving us the middle finger,
Yeah,
saying he's not going to
yeah,
do it. I
and
mean,
I
that's,
And he made an effort to take it off the front page of the LinkedIn. But then he attached a resume and a bio to the LinkedIn and used it there. He does say that he's CPA inactive, but I explained that you can't even use that
Right.
if
right.
you're not,
Well,
have a
he's-
current license
yeah.
anywhere. But
Yeah,
that never got changed after repeated attempts.
So did he change from CPA to CPA inactive after you notified him?
He took the CPA off the LinkedIn front page, and then the next time I checked, there was a resume and bio added, and embedded in that it said CPA inactive. And I looked at it then and emailed and said, that's still not allowable under our laws because you're not an inactive CPA. You're not licensed anywhere.
Take it down then?
No. It's still up as of
does
this
his
morning.
website say inactive as well?
Excuse me?
Does his website say inactive?
No, his website says CPA.
I mean,
Just as a full disclosure, I'm not on the committee, once again, everybody understands. But I would suggest to the committee that you consider $2,500 on the penalty.
How many days has this been going on?
Well, when was the complaint filed?
'Cause you said we can do
it's been
1,000
happening a
per
lot
day.
because
2 years
he's not been able to use that designation since 2009 anywhere.
I mean,
Yeah.
I recommend it be 5,000, and then if with the ability to settle at 2,500.
Well, settle, you're not negotiating with them, we're imposing penalties.
Giving them haven't we done that in the past?
You'd have to do a hearing, and then
Oh,
in lieu of a
okay.
hearing, you would have a settlement offer amount.
Well, no,
Right.
we've allowed our legal team to have the ability to, with the ability to settle at a lesser amount before.
You can
We have.
you can issue a civil penalty, and then also in the alternative, reduce the civil penalty if he will abide by the law. If he will
Yeah.
take off the CPA designation.
That's an either or that this body is setting, not allowing y'all to make that determination of the penalty.
No, you can make that. You can make that motion, and then we would change our proposed order showing the same.
And now we're giving them a reduced sentence to comply with the law. I mean, to me, this is pretty serious. I mean, I wouldn't go that direction. I mean, I personally believe this person has done what they've done intentionally. I'm amazed that they figured out CPA inactive. Obviously looked that term up somewhere, right? But didn't notify the fact that he'd never been licensed anywhere. So and to have not fixed anything at this point, I think that's a real problem. So I think if you're going to go 5, go 5. If you're going to go 2,500, go 2,500. But I wouldn't say, hey, we really want you to comply. We'll knock 2,500 if you'll just go do what you're supposed to do.
I make the motion that we fine him $5,000.
We'll consider that an amendment to the motion to change the
okay,
civil
sorry.
penalty to $5,000. Is there a second for that amendment?
A second.
We have a motion and a second on the amendment to modify the recommended penalty to $5,000. Is there any further comment or discussion? We'll take a vote on the amendment, and then we'll take a vote on the underlying motion. So all those in favor of the amendment to adjust the civil penalty to $5,000 signify by saying aye. Aye. Is there any opposed? Any abstentions? Okay, we'll now vote on the main motion, which is to authorize the civil penalty in the amount of $5,000 for using the designation of a CPA without a valid license in Tennessee or reciprocity through another state. Is there any further discussion?
I think the way that it's worded there with the reciprocity, I mean, he never had a CPA license.
He never had a license that would be reciprocal in the state of Tennessee.
Yeah, so it's not, it's for I mean, do we have that titled correctly?
I think so. I think what it's getting at, Judy, is without a valid license in Tennessee or really without reciprocity. So the way I interpret that is he didn't have either one.
Right. Okay.
Okay.
All right.
Any further comment or discussion? All those in favor of the overall motion with respect to the assessment signify by saying aye. Aye.
Aye.
Any opposed, say nay. Any abstentions? Okay. Item number 13, case number 13. From a background perspective, the folks, particularly at the Contractors Board, but also other regulatory boards, give us a number of referrals throughout the year for people doing reports, issuing reports when they have not been subjected to peer review. And this is the first of a couple of cases that are going to be discussed here. In case number 13, this is a referral here with respect to performing an audit for a utility district. The firm was not enrolled in peer review, and the respondent admits the violation. So the staff recommendation is for the civil penalty in the amount of $3,000 for failure to enroll in peer review, and then to require him the firm to enroll in peer review within 30 days or submit completed peer review to the board by March 31, 2020. Any comment or discussion on this one? I think $3,000 is pretty much the standard type of recommendation when an audit report has been issued. Is that correct?
Correct.
Okay. Further comment or discussion? I'll offer a motion then to authorize a civil penalty in the amount of $3,000 for failure to enroll in peer review and to require firm to enroll in peer review within 30 days and submit completed peer review to the board by March 31, 2020. Is there a second?
Second.
We have a second. Is there any further comment or discussion? All those in favor, please say aye.
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 Any opposed, say nay. We'll proceed to item 14. This is a referral with respect to the Tennessee Motor Vehicle Commission, which received a compilation report dated in April by the respondent, and they asked our board for assistance in license verification of the respondent. It was noted that the firm's permit was revoked in April of 2018 for failure to re-enroll in a peer review program, and in August of 2017, the respondent had been terminated from a peer review for failure to complete the corrective actions from its previous peer review. And so we see some history there as a result of that. The staff recommendation is for a formal hearing with the authority to settle via consent order upon their voluntary suspension of their individual license for continuous failure to enroll in peer review, and their individual license will be reactivated either after upon notification that the respondent firm has re-enrolled in peer review or for 6 months after the respondent's firm has completed the exemption form relative to peer review. So that is the background. This entity has previously been fined with a $5,000 civil penalty for failure to comply. Any further background from staff on this particular case?
Firm permit, as a reminder, is in a revoked status.
Question on that, would there be any additional CPE required, or, I mean,
we could. I don't know that this is a learning
Okay.
opportunity. The firm knows the individual knows what they're doing. The other thing to remind everybody is that a suspended status, if he accepted this consent order, suspended status would not allow him to use the designation for the time period he's suspended, but he'd still have to renew and still have to get the CPE, required CPE.
is it okay for me to ask for, do you feel like, I guess the question in my mind is, should he be able to just get his license right back, knowingly doing these things? It's not the first, he's not complied the first.
If he agrees to the voluntary suspension, he has to come before the board to
Get his license.
to get his license
Okay.
back.
I'm not so sure I'd let them come back until they go through a peer review process, because they never did, right? They issued reports, paid a fine, but then never fixed the problems, never.
Yeah, it looks like from what I can tell and recall here is that the firm was terminated for not completing corrective actions, and then,
Still wasn't enrolled, right?
right. And then
That was suspended.
we required him to re-enroll. He did not do that, so the firm permit became revoked.
And they did pay the penalties?
I believe so.
Obviously wasn't stiff enough for them to change their.
Still cheaper than.
Yep. I don't know if we consider changing that, since it's, I don't know. I mean, if it costs them less to pay a fine than to have to go through the.
Well, now he's losing his individual
Okay.
license, I
Okay.
guess,
That'll
is the
help.
issue.
Yeah, that'll help.
That's kind of the consistency on the matrix.
I think the next step, I mean, we fine him the recommended amount of the fine previously, and then the next step is the suspension. So I think this is consistent with that, and he won't get it back until he comes before the board.
If he chooses not to sign the consent order or agree to the suspension, then we would have a hearing.
Further comments or discussion on that?
Were you looking to see, Wendy, if he paid the fines?
Yeah, it's not the easiest thing to, but yes, I'm trying to see.
Sign up for that Excel. No, I'm kidding. I'm totally kidding. I think that database is very easy to navigate.
Is there, are the committee members willing to entertain a motion as recommended by staff relative to the formal hearing with the authority to settle via consent order upon respondent's voluntary suspension of the individual license? And it will be reactivated either after upon notification that respondent's firm has enrolled in peer review or for 6 months after respondent's firm completes an exemption form. But in essence, the board has to take action before a suspension is revoked. Is there a second to that in the form of a motion?
That last sentence is it worded the way it's supposed to be worded, after upon notification, is that? Like, I'm just talking words here, but
Yeah.
after upon notification.
Yeah, let's just strike the word after, yeah, or upon
Or either
reactivated.
after notification would be okay
Yeah,
too, but
yeah.
or for 6 months. So that means if he completes an exemption form, that he's okay for 6 months, and then there's a follow-up. Is that what that means?
Yeah, the way I would interpret that, if we're into if he decides to go the exemption route, meaning that he is not going to enroll in peer review, but he's basically saying that he's not doing anything that requires peer-reviewed work, then that would be, it would be 6 months after that. Well, he would still not be able to do anything that would require peer review.
It says reactivated for 6 months after. Isn't that right? So reactivated either after upon or 6 months. That the sentence is not clear to me. Is it?
Can I try to clear that up? What we're asking is that his individual license be suspended until he reactivates or re-enrolls into peer review. And then when we receive notification, we will have him go through the steps to get his license active. If he decides to file an exemption form, then he will be suspended for 6 months from the date of that form, and then we'll have to go through the process of reactivating his individual license.
But his
Either
firm-
way, it has to come before us.
Yes.
Yes.
Okay.
Oh, okay. And his firm permit is still revoked.
It's revoked, yes.
If you took out the word "for"
Yes,
there,
take out the word "for" because it sounds like
4 6
reactivated
months.
for 6 months. It's reactivated 6 months after.
We'll get it changed by tomorrow,
Okay. All right.
and he also did pay in 2017, he did pay the full amount of the civil penalty.
Thank you for looking that up. So I think we're looking for a second then to that motion.
Second.
We have a second. Is there any further comment or discussion? Not. All those in favor of the motion signify by saying aye.
Aye.
Aye. Any opposed? We'll go on to item 15, which is our last proposed discipline item before we get to the one representation item that we have. This is one of those cases that was referred to us by the Board of Contractors, where we have a situation where the respondent issued a review report and never completed a peer review. The respondent agreed that the firm had not had a peer review, but believed that the firm was exempt from the requirement based on, in his words, the fact that he was told that upon enrollment it would not be required for the attest engage assignments of one tax client because he was a member of both the AICPA and the TSCPA. He does state that he's willing to comply with the request of the board regarding this matter if his understanding was incorrect. It was incorrect, an incorrect understanding, and he technically was in violation here. But I think in this particular case, he was willing to remedy the violation immediately once it was drawn to his attention. And so in this case, the recommendation from staff is to authorize a consent order for the respondent to complete its peer review within 180 days and also adding the owner of the respondent firm to the automatic CPE audit list for the upcoming cycle. Any further background on this one from staff?
The only thing I'll add is this firm had not enrolled in peer review till 17. There wasn't a need to before then. So this was not something where we were notified that, he was not compliant with the peer review program. It was simply a referral from the Board of Contractors. And when they did the verification, they took that extra step to say, well, he's enrolled in peer review, but he hasn't had one, and he should have at this point. And the other thing I will add is last week I did receive notification from the respondent that he is in the process of scheduling that peer review.
So he's
She
enrolled.
gave me the
and is-
screenshot from
Okay.
Prima and all that good stuff.
All right. So it sounds like he's been reasonably cooperative.
Mhm.
Okay. I guess the recommendation here would be with respect to the consent order for him to complete the peer review within 180 days and then follow up to put the owner on the audit list. Is there a second? And then we'll open it up for discussion. Second, any comment or discussion on the recommended penalty for this one?
I'm just curious, is 180 days, is that enough time to get something?
In this situation, it's my understanding that he does not do audit work, and so it would be an off-site peer review or engagement peer review. So, if he does what he needs to do, then yeah, I think it's reasonable.
Further comment or discussion? Okay, all those, I guess we have a motion and a second, so all those in favor of the recommendation, please signify by saying aye.
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 Any opposed, say nay. Okay. We'll go to our final case here, which is a representation. And in this particular case, effectively the respondent was operating under an SEC order. And this was placed previously on a litigation hold pending the outcome of various lawsuits. We now have new information where the arbitrator has issued a final award that was confirmed on January 23rd in 2019 by the court, and it confirms that the respondent did have oversight responsibility in regard to the SEC violations cited. So it appears that although a motion was filed to amend the judgment, it does not appear that that motion will be successful. So we're basically now at this point, staff is recommending the authorization of a consent order wherein the respondent CPA shall comply with the terms of the SEC order and shall be placed on suspension until December 12, 2020, which is the date in the SEC order that would be outlined. And so really what we're recommending here, which I think is typical in this kind of a case, is concurrent discipline, whereby the state board will also basically suspend, place on suspension until the terms of the SEC order are completed. Any comment or discussion on this one?
Statement that the respondent denies any responsibility for accounting, financial reporting, and internal controls of his employer despite his CFO designation? Under the SEC and the AICPA, I don't think he can say that, can he? I mean, the audit report requires that the CFO take responsibility. Am I wrong?
You're absolutely right, and the SEC agreed with you. So they have.
I'm a little shocked.
I think they may have been too, because they decided to pretty much throw the book at him. It looks like, from what I can tell here, and so we're being. I guess our normal step here would be to recommend concurrent discipline. Any further comment or discussion? Is there a motion then to authorize the consent order wherein the respondent CPA shall comply with all terms of the SEC order and shall be placed on suspension until December 12, 2020? Is there a second?
Second.
We have a motion and a second. Is there any further comment or discussion?
Just, he would have to, again, come before us to get that, right?
You know, in thinking about, that's typically what we do. I think the board, when they review the application to reinstate the license, can choose not to have the person appear. So I have seen it in prior orders where it says the person must appear,
Okay.
and then the board doesn't have any authority at that time. The person must appear. So you could put that in the order if you wanted to.
I think we should. I mean, given the title and position in that company and saying he didn't, I mean, I think that person needs to come and explain kind of the position and why they feel like they could be and ethical and you know, be in a position of being a CPA and that designation. I don't think to claim no knowledge and no responsibility of the things he claimed, I think
That was
that
a lack of knowledge of
Yeah,
the
I mean, that's
regulations
scary
of
to
the
me.
profession.
I think we would just need some sort of, I don't know where we are. Have we already voted on it? Or do we have a motion?
No, but this would be amending the
Amending
motion
the motion.
basically
Okay.
to indicate that the respondent must appear
appear.
before
Yeah.
the board prior to the lifting of his suspension.
I second that.
Well, I think you made it.
Okay,
so we'll
I
have to
made
have
it.
another
Okay.
second here. So, is there a
You would
second?
have to amend that.
I'll second it.
Okay, so this is with respect to the amendment, which is requiring the respondent's appearance before the board prior to the removal of his suspension. So we'll vote first on the amendment. Is there any further discussion on that? Okay, if not, all those in favor of the amendment, which is requiring him to appear before the board, signify by saying aye.
Aye.
Aye. Any opposed? Okay, now we'll go to the main motion, which now, as amended, indicates that he must appear before the board and reaffirms that his he has to the consent order, he has to comply with all the terms of the SEC order and will be placed on suspension. Any further discussion on the overall motion?
One question
Yes.
or comment. I agree with the statement that it's unlikely that the motion will be unsuccessful. But given that there's some time since the respondent filed the motion challenging the arbitrator, do we have I'm not as familiar with SEC arbitration, a timeline for when that might be resolved? There is a final award, but there's this kind of open end here that something could be changed. I agree, though, that it is unlikely.
Right, and that's the reason why we're representing it. So it's not just sitting out there, but there's no timeline. I don't know about the arbitration. I know that he continues to appeal,
Right.
and so that's why we're bringing this to the board so that we can go ahead and get it finalized.
And it's not SEC arbitration.
Right, and it's not the SEC arbitration. It's actually the lawsuit that he's appealing, where they were awarded damages. His employer was awarded damages.
Correct. Thanks for clarifying that. That's right.
Still has to comply with the SEC consent order regardless, which is really what we're saying he must do.
Right.
In addition to suspending his license until he does comply.
Right, yes.
Okay.
I'm not on the committee, and I have no issue with this particular case. It was more just make sure what loose ends were out there. So,
There's one comment on the line before previous recommendation. I think there's the word "like" is missing in that last sentence. Or previous recommendation. Says he would like to keep his CPA license in good standing. Is that right? Doesn't change what we're doing, just comment.
Ready to go ahead and vote on the overall motion then, which includes the requirement for him to appear before the board. All those in favor say aye. Aye. Any opposed say nay. Okay, I think that concludes the report of the Enforcement Committee, Mr. Chairman.
5 or 10 minute break. 10 minutes? Is that good? You may go.
Go ahead and start with that, I guess.
All right, whenever you're ready, Stephen or Gay.
Okay, this is the Law and Rules Committee, and the first thing on our agenda is an update on our pending CPE rule and our continuance testing rule, and I'm going to let you provide that update for us.
Okay, there's nothing major really, but the nano learning and CPE rule, let's see here. So we have our, sorry, I have a chart, but anyhow, it's proposed to go in effect on September the 4th. And we are going before the Joint Government Operations Committee on August 21st. And that's also going to be our sunset hearing for the board. And they've asked that we bring a board member, so I'm sure Wendy can maybe talk to some of you about that. And then the continuous testing, that has been approved internally, and it is right now at the Attorney General's office, and we're working with them to get pre-review of constitutionality before we then submit to the governor's office. So that's where we are on those two. If you have any questions, happy to answer.
The second agenda item is considering a rule change to allow course instructors to receive additional CPE credit beyond the current 50% maximum. And we have a guest with us this afternoon, Mr. Sotinsky. Yes. Okay. And we're going to have him talk to us a little bit about his thoughts on this.
All right. If I may give you a little bit of my background so you understand where I'm coming from. I'm from Philadelphia originally. Undergraduate degree in accounting from Penn State University. Am I allowed to say that here? I received my law degree from the University of Pennsylvania and my master's in tax degree from Temple University. I spent all of basically 47 years practicing accounting except for 1 year when I practiced law, and that in the middle, and that convinced me that I was better off as an accountant. Essentially, I have been a tax and financial planning specialist, except on the financial planning side, I don't take assets under management. And I haven't practiced law. I don't draft documents. I basically do tax planning and tax return preparation. We moved down to Nashville about 13 years ago because our daughter who was getting her degree in physical therapy, was getting her practicums around the country. So she puts a map up on the wall and throws darts. And one of them landed in Nashville, and this is where she met her husband. So once she started having kids, we made the decision to move down to Nashville, and it was the best decision we ever made. Our son was single at the time. He then got married, and he and his 3 daughters, including twins, are now here, so that couldn't be better. My practice is fairly limited right now because I was like 60 years old when I moved here. And I prepare tax returns. I do some planning occasionally for different people. And I teach. Most of the teaching I do is for a surgeon who provides continuing education courses throughout the country. And I will teach probably 16 or 17 days or so for him. It is not financially lucrative. I may get paid $800 for teaching a day, and including the travel time and the preparation time, if I make $10 an hour, I'm lucky. But I do it because I enjoy teaching. And one of the benefits of Surgeon is that the majority of the classes are smaller. So that I'm in the position to provide the students with more than just a voice, but rather someone who is there to listen and to provide them with additional information and make them better practitioners. I learned that when I got my master's in tax, which was an evening program, and I saw how I paid attention far, far differently than I would in the undergraduate program or even law school, because I was already practicing, and my intention was to add value. So I do this, and it's very important to me. And I don't think I'm the only one. I think you'll find that most of the people who provide continuing education, who spend the time preparing to teach courses, are serious about communicating and serious about adding value to the listeners. So here I am. If I look at my schedule for 2018 and 19, I'll teach without duplication about 64 hours or 8 different courses, okay, that in my mind would qualify if I were just taking them, okay? And the amount of time I spend preparing for them is just as much as it is for the 2 days that I get the 3-for-1. So it seemed to me that as a presenter and someone preparing for it, I have no problem. In fact, I think it's appropriate that I only get 1 hour for each hour I teach beyond the 3-for-1. And I was really surprised when I realized and learned that the state rule, and this was conversations I had with Wendy and Linda, that it's limited to basically the 50 hours or 40 hours. So it really was a surprise. And it seems to me that if you want good presenters, people who are teaching more than 1 or 2 days over a 2-year cycle of different courses, think about the amount of time incurred to prepare for different courses, that they should be able to get at least 1 hour for each hour they teach beyond the 3-for-1. And that's really what I'm presenting to the board and to all of you. And I could go on, but I think you understand where I'm coming from and what I'd like to see. What I think is fair and appropriate.
Okay.
Okay?
Does that make sense? You are a Tennessee CPA.
I am a Tennessee CPA. I've been licensed since I moved down here. I'm no longer a Pennsylvania CPA, although I'm still an honorary member of the Pennsylvania Institute and the American society, AICPA, American Institute of CPAs as well. That means I don't have to pay dues, but that's about it.
Hour for each hour that he's presenting in addition to that inclusive of the
No, that's
included?
what he's basically
Okay.
asking for.
Okay.
So right now, the max amount of hours he can obtain as a presenter is 40 hours. And so the other 40 hours that he's required to obtain, he would have to get outside of his instruction time. And so he is asking for some consideration to allow not the 3-for-1, but once he hits that max, can he get hour for hour, correct?
Yes.
Hour for hour, even though he's still presenting, but get the hour for hour that he would get as an attendee of his class.
I typically take the ethics course from a third-party presenter. I take some other courses over time. But at the stage I'm in my career, especially, where this is such an important part of it, the amount of time spent and so forth, it's very important to me.
Hey, Wendy, this has come before us before, hadn't it? Have we not had this conversation
I recall, but maybe it was before me.
before you?
So under your request, would there be any limit at all based on your, I mean, if you presented every day of the year, you could get 100% of your CPE by presenting as opposed to going into any classes? Is that?
Yes, aside from, well, even if I taught ethics, although, I don't think it's appropriate for me to teach an ethics course. But that's essentially what I would like to see.
But if you were teaching the same course over and over again.
I would not, no. I do, no. Oh, this is each course once. And as I said, I'm teaching basically 64 hours over the 2-year period of different courses. 8 different courses, basically.
I think where we run into an issue is we have certain people who teach certain things over and over again.
But that's in the rule. It says you cannot receive credit
Right.
for the same course. I'm probably the only board member who receives 40 hours of my CPE through instruction because I'm a professor. And so I've tried to think about the rule and how it came to be and why, and I guess the reasoning is that you're encouraged to learn from someone else for half of the hours. Wendy, do you know the reasoning behind the wording of this rule? It's been this way for many, many years, as long as I can remember, because I use it.
I think you're right. I think, now I can't remember who told me this or where I got this impression, but I think it's because, and I agree with it, I don't know that it has to be 40 versus 40, but to me there ought to be some amount of your 80 that comes from someone other than your self-study and preparation for courses. Now, whether it should be 20 or...
Self-study limited? I don't remember.
No,
Not anymore.
Not
It used
anymore.
to be.
not in our state.
So, yeah, so when you start getting into those issues where self-study is not limited or using online learning and so forth, then are you really learning from someone else?
Yeah, but at least with self-study and online learning, you have to document where you got it, where it came from.
And
In the case,
questions, right?
yeah, and in
Well,
the case of your,
for example, I have a
preparation,
letter from surgeons confirming the courses that I taught for 2017 or 2018, and we'll get the same letter for 2019, so that you'll know exactly, not the number of times I've taught it, but just which courses I taught.
Yeah,
I have a listing here of the
Yeah, I didn't mean
courses.
you wouldn't have a documentation of what you taught. I'm saying in the case of self-study versus your time spent preparing for the presentation, the self-study is actually documented that where
3
you got
hours
it,
or
what
2
you
hours
did,
or whatever.
you spent this much time, whereas your preparation for the courses that you're teaching yourself, there's really no documentation of that. I'm just saying that's the distinction.
Agree.
Well, but if they're different, wouldn't there be a syllabus or something that goes along with that coursework that he's teaching? I mean, you've got documentation of what he covered.
Yeah, but you don't know how long he spent getting ready for it.
But even then, if he's in a classroom you're in a classroom for much more than 40 hours. I mean,
There is some online instruction where the instruction is minimal. I mean,
Yeah.
just the format. I have friends, students, et cetera, who've taken courses where they're given a book and the assignments, and the student does all the self-learning. So I don't know. I'm certainly not saying that's the way you teach, but I can understand that. I can understand where this rule came from to say, well,
it could get abused.
we trust you
Right.
for half, but not for the other half. Like I say, I've looked at the rule quite often.
My perspective is, I'm very happy with the 3-for-1 for the 2 days
That's
taught.
appropriate, yes.
Anything beyond that, they are totally different courses that I'm teaching 8 hours for. And those are the ones I just look for one day. And I think it's appropriate for presenters who are in that same, I don't think there are that many, but if you have presenters who are teaching that many days of different courses, of different material, then the material beyond the 2 days that they get, or the 16 hours they get 3-for-1, that they should be entitled to 1 hour for each hour they teach of those different courses.
It would probably affect all professors in the state who are CPAs as well.
How do you regulate though? Like, we'll use ethics for example. If you wanted to teach ethics, you would get the material from the TSCPA. It's already prepared. You're just delivering the message. There's no prep time. How do you determine the person that should get it for preparation and the person that just gets the pre-boxed presentation and presents it? I mean, that's my only concern, is it opens up that now we got to police it.
Well, I mean, if someone, I'll suggest to you that, and you're being a teacher, even if you have a pre-boxed set of materials, you still have to spend some time reviewing them, getting comfortable with them, and being able to convert them into presentable materials. You can't just read those materials, in my opinion. I mean, again, that's my style. That's how I approach teaching. My approach to teaching is for people to learn, not just for me to communicate or dictate is probably a better phrase.
Really, it seems as if your request or concern relates simply to the 50% limitation that Tennessee currently has on the what I'll call the instructor hours, if you will. And I can understand that, although I still have an active license in Nebraska, where I'm originally from, and they have a very similar requirement in terms of instructor-led training. And there have been a number of years where I have maxed out the instructor-led hours that you can have to count. And I guess I'm less concerned if the courses are different in content and you're actually teaching different courses throughout it. There's no repetition. We're clearly willing to allow it up to a 50% limit already. I mean, we're, I guess, policing or not policing that, as the case may be already. And then the question in your case is, well, if you're legitimately teaching, a number of separate courses, really what was the reason for that 50% limitation? And was it, as Larry, I think, was suggesting, maybe it's nice to have training from someone else, to inject independent thought and so forth, rather than all of it be, simply from your own preparation and development. Is there any percentage in between 50 and 100% that you would be comfortable with?
Well, I mean, I'll be quite honest with you. If I look at the number of hours that I teach of different courses, okay, I'd give up the 3-for-1 if I can get 1-for-1 for all the hours I teach. Going to the other extreme.
Go that way, we're going to have a whole line of other
Of course.
people.
Of course. And I'm not suggesting that. What I am suggesting is that you do have people, including myself, who do teach a lot of continuing education courses, and they are different courses. And for them not to be able to get credit for those other courses beyond the 3-for-1, it just seems inappropriate.
There are new things to consider now that aren't relevant to your situation, but for example, I know schools that are giving, we've talked about it, giving academic credit for Becker, and in some cases, there's a professor assigned to the course. The professor gets credit for the course. A few years ago, the professor would just come in and turn on the video. These days, the student may or may not even come into the class, but still on paper, that person is teaching 3 or 4 academic credits for a whole semester. So I think the reason for the limit, and I would benefit if we did away with the limit, but, benefit in some ways. I think the reason for the limit is because there are so many different situations that fall under this, and while you are spending many, many, many hours in preparation, some teaching assignments don't require that. Professors, what you get for continuing education instructs you totally differently from what you do to teach, say, an undergraduate course.
All right, but let's take one of the courses other than the ones I'm getting 3-for-1, okay? If I were sitting in on one of these other courses that someone else was teaching, I'd get the 1-for-1. So why shouldn't I get the 1-for-1 if I'm the one who's up front?
I want you to have a perspective of hearing what someone else says about that topic without every bit of your learning being self-generated. We want everyone to have a blended, and we realize, I think, that your case is unique because not everyone is doing as much teaching as you may be doing. But if we open that door, we can't. There are others who would not be maybe as diligent as you would be in complying with this rule and so forth. So we're just saying we want everyone to have a perspective of other people's thoughts too, as opposed to 100% of it being your own research, your own preparation. That's my thought. I think that's why the rule is there.
I understand that, and again, a good teacher will do a good job of getting feedback and interaction with the students, which sometimes catches them, which is terrific. I love it when I get a question I don't have an answer to off the top of my head.
We understand that, but you've sat in here during a lot of this session this morning and heard a lot of the topics we've talked about. Not everyone is as self-compliant as you may be. So we have to make a rule that covers everyone and try to be fair to everyone. So
I think that it was a compromise, but the first part of it was considered somewhat generous in that you get 3-for-1. And so by giving you that, it's a way to say, okay, now we feel justified in making you go and get other hours because we did give you time for your self-study and preparation for the...
Would some modification make sense? 40 hours, 50 hours, and then from that point on, for half the difference, you can get the hours from teaching and the balance, say, from attending?
Can I ask a question? And I don't know, the AICPA, CPE, or surgeons, do they not issue certificates to the facilitator or the instructor?
Yes, they do.
Do you get one of the, do we count that CPE certificate? We do not count that.
I know they issue them to the attendees.
But
okay?
do they issue them to the instructor?
If I get, as I said, I have a letter from them confirming.
But as an instructor, not as an
Okay.
attendee.
Okay.
Yeah.
Okay. That's what I was trying to figure out.
I think that I think you all have an understanding of what the request is, correct? Are there any more
I just, one question to clarify. So you teach 8 different courses. So say in a school year, I don't know how many of the 8 different courses you teach in a school year.
Over the 2-year period, 2018, 2019, okay, I will probably teach about 20-some days, okay, but there are 8 different courses.
I guess where I'm trying to go with this is, would you be getting credit for the same courses over and over again?
I'm not looking for that. No, I don't think that's appropriate.
And I agree, but yeah.
Yeah, no.
But I don't know how
redundant
the courses that you're teaching
Well,
are.
I mean, they all tax related or financial planning related to some degree. All right, there's some redundancy of some of the materials, but from a different slant, from a different perspective.
And then you teach the courses over and over again for
in 3 different
certain
cities.
years?
I may teach a course on 1041s, trusts and estate tax returns in 3 different cities. But I'll only take credit for it once.
And then say the next year, if you teach those same courses?
If you teach the same course in the next year within the 2-year cycle, I may teach those courses again, but I don't count them in the same cycle. And then I have to take a look and see what's happening to the law and how it varies from 1 year to the next.
To see if the course is really different.
I wrote a course for surgeons. I wrote a course, a full 8-day course called Tax Aspects of Business Planning, which went through the life cycle of a business and all the tax issues along the way. I can't tell you how many hours I spent preparing that, and I don't even want to get into whether I should have or whether it was appropriate for me to submit that for credits. But I know what's involved, and I know how the law changes, and I know how the approach to the tax law will change from generation to generation, from year to year, from administration to administration.
Indeed, do we know what the rules are like in other states surrounding Tennessee?
So the document that I provided you all, the second page of that document has the information that NASBA pulled for me on other states, and if you have your reading glasses, you might be able to see it.
I do. Anybody needs to borrow them.
So I guess I tried to get it all on one page was the issue there, but just to summarize it looks like there is a limitation in 41 states and no limitation in 14 states. And they range all over the place as to the type of limitation, but most work around 50%. Some states have a 3-year reporting period and talk about a number of hours per year. Some talk about the percentage of total hours. So there's varying ways that people do CPE or calculations, but the limitation, 41 states have some type of limitation. And with Mr. Satinsky's situation, he maxes out with 2 courses. So just to put that in perspective.
Those other states have the 3 times rule. Is that a consistent thing across?
Yeah, ours is consistent with the model rules. So yeah, I mean, I can't say exactly, but this stems from the model rules on CPE.
I think it's worth considering options or alternatives or varying the rule. I believe it's appropriate. I think it's fair to the presenters. I think it encourages better presenters as well, hopefully better presenters.
Questions for Mr. Okay.
Oh, I have one. Well, for Wendy, actually. On the states, I'm noticing some states in the Southeast, a good many states in the Southeast, have no limitation. So my question is, was there a limitation and has it been removed, or was that, and I know you may not be able to answer that right now, but, or has that been a modification, or is it just never been addressed?
I don't know that I know the answer for sure about whether it's been removed. I would say that most people that are undergoing changes in CPE right now, their rules are related to coming into compliance with the model rules.
Okay.
And so I would not think that that was a recent change, because the rule we have and the changes you see on that front page, I mean, that's with the model rules.
Okay, okay.
Questions? Mr. Thank you very much for coming.
Thank you for listening to
sharing
me.
your perspective. I think the board will talk about it, and,
Turn.
okay.
Thank you all very much.
Our rules are NASBA's model rules. We've got that change that comes into place.
Yeah, that's a previously
September,
approved change
right.
that will come into place, become effective September 4th.
And that was a result of being
That was
meshing with NASBA's rules.
Meshing with NASBA's rules, and also, to be honest, to give a developer the chance to receive CPE credit. So it was a slight expansion, because before we just referred to instructors. So sometimes you have a developer and then you have somebody who teaches the course, and it really wasn't clear that we were allowing that developer to receive any CPE. And in this case now, they would have the option to receive some.
I think, if I could say something here, I think we all have a great deal of respect for our educators, and Pam, we respect y'all so much, and we appreciate folks like him, being willing to teach as much as they do and back to the profession and to the students. At the same time, I think our present rule is pretty fair. I think the 3 times rule is good. I just think it's good for everybody to get a outside perspective of someone else other than what they've generated from their own study. A self-study, I think, is a little different in that you are at least taking a course that someone else put together. Preparation for a class, if you're doing the research in the wrong areas, there's nobody there to tell you that. At least we're not giving them 100% of all of it. I just think it's good for all of us to have another opinion from someone else. Perspective. That's just my opinion.
Agreed.
Other comments from anybody on the board or on the committee? We are in line with everybody else, and I'd hate for us to move away from NASBA when we've worked so hard to be in a line with the model rules, and having another one-off. Anybody want to make a motion for a recommendation to the, is that what we are?
There's no motion to be made, is there, since there's no change?
Yeah, I guess you'd only make a recommendation if you were proposing to change something.
Okay, so.
I like the recommendation that we leave the rule as it is.
Okay, that's
fine too.
Okay, so do we need to have a motion to make a recommendation to leave the rules as is, or do we just drop it?
I think it would be good to note in the minutes that it was discussed and that you chose not to move forward with a change.
And Larry can actually make that motion because he is on this committee.
Maury could make that motion. It's open. Just can't do it today.
So we do want a recommendation and a vote.
I mean,
a motion.
that would be good.
Okay, I'll make the motion that after hearing the proposal that we have in front of us, that we leave the rule as is.
Second that motion.
All in favor, say aye.
Aye.
Aye. Any opposed? Okay, we will make that recommendation to the full board tomorrow. I think that was it for the Rules and Laws Committee.
All right, we'll go ahead and start the Executive Committee meeting. It's supposed to be short items, but we haven't done too well today so far, but we'll give it a shot. We got 3 items, travel, and then discuss the financial report results, and then there was a proposed travel budget amendment that's been brought up. So I'll start. I'll just turn it over to Wendy to let her kind of discuss the travel and the financial side.
Okay, so the first one is simply the travel for the last quarter for Sherry and myself, and it's just typical. We report on the travel that we've undertaken in the past quarter. So it lists my travel to TSCPA's convention as well as NASBA's Eastern Regional Meeting. And Sherry had a some small travel expenses with an investigation during June. So that is the total of the travel report. And for the meetings, TSCPA or NASBA meetings, the registration fees are not included in this. So this is strictly hotel, per diems, those types of things. Questions? The next item on the agenda is the fiscal year 19 financial results. So I don't have the year end yet. I don't have June 30 yet. So what we'll be talking about is our May numbers. So on the first document that you have is our net position statement that we receive each month. Has our total revenue year to date at $948,340. Our expenses are at $822,086, leaving us with a surplus currently of $126,254. Of course, our main revenue months are during renewal season, November, December, January. So we will likely not see a lot of revenue in June, but maybe similar to the month of May. Total expenses have been running anywhere from $66,000 to $90-some thousand a month. So that's what we would expect to see in June. So I think with those numbers and the current surplus of $126,000 that we should end the fiscal year above the line. The second page details out our Edison expenditures, and I've compared it to the prior year and also compared it to budget. So again, you'll see our revenues at $948,340. You will notice that we have, and this is a little education for our new members, so the revenues less our state regulatory fee. The regulatory fee is a fee that's charged for each license, individual license that is renewed to active status. And so that's just a fee that we have to include in there. So, and in our revenue numbers, we do not include case and complaint in the budgeted number. So typically our revenues, the actual numbers will include some case and complaint. So those will typically be above the budget. Our licensing revenue is up this year by about $6,000, but our case and complaint is down by roughly $18,000. So we are a little below the prior year, but we're definitely in line with budget as far as our revenue numbers. Salaries and benefits are favorable to budget. Our employee benefits are trending a little bit lower than the prior year. I believe that's related to our health insurance. Premiums were less in this calendar year, so that has helped us a little bit. We also had a staff member on maternity leave during that time. Longevity compensation, we are unfavorable to budget here, but we have seen the total expense for the year. This is related to staff members who were hired prior to June of 2015 and have at least 3 years of service. They qualify to receive $100 a year for their service on their anniversary date. You will also see pay for performance, one-time payouts, and bonuses included in this line item, and those are typically hard to plan for. So that number was a little higher than expected this year. Our travel is favorable to budget and to the prior year. We do not have the June regional meeting, NASBA regional meeting expenses there yet, but we were able to file, I think, all but Andy's in June, so we should see most of that. in the current fiscal year once we get the June numbers. So that will bring us closer to the prior year, but I still feel confident we'll be less than our budget there. Communication and shipping, favorable to budget. Of course, these are postal charges, mainly from our wall certificates and renewal notices. Of course, there are a number of items we have to send certified mail, so those shipping charges will be there as well. Third-party professional and administrative services, that's favorable to budget. This includes our shredding, expenses incurred for our formal hearings, NASBA dues, credit card processing, GPS service, and any other third-party items. So a note on the credit card fees, I understand that the state has signed a new contract, bless you, lowering those fees from 2.9% to 2.3%, so we'll see a little bit of savings there. That starts August 1st, so that'll be a nice savings that we might see. Supplies and furniture, food and beverage for our meetings shows up here in addition to any office supplies. We've been far less than our budget there. Rentals and insurance. We have started renting cars if we're traveling over 50 miles, or I have, I guess is the best way to say it. So that was not a line item we had a budget under, but we did have an expense there. Motor vehicle operation. This was a one-time addition of a GPS device to our one car that our board has, which Sherry drives. Awards is recognition, any recognition items that we have. Employee training, this is favorable to budget. This covers training for professional staff, so the CPE that Sherry attends, which much of it is free, so we do pretty good there, so about half and half. And registration for NASBA events shows up here, so those registration fees for the regional or annual meetings for any of the board members or myself shows up there under employee training. We have everything, all of the registrations for that regional meeting were included, so we have hit the total for that line item this year. Computer-related items, any of our technology purchases, copy or fax rentals are included here. Last year we had a charge for our Zendesk platform, which is the equipment that we use or that the customer center uses and our staff uses to take calls and record calls and document email tickets. And we were charged specifically $3,500 for that last year. My understanding is that came in, was allocated this year rather than a direct charge. So it was allocated based on the number of tickets that the customer service center saw for our board. So it actually worked out in our benefit. I don't know if it will continue that way or not, but I had been waiting for that $3,500 expense and it never came, so I finally asked about it. Yes. Yeah, so it came down in cost backs under the customer service on your net position statement. But it came out to be a far less expense for us that way. State professional services. This is our telephone, rent allocation, printing, lease rate on our car, fuel usage charges. Our rent allocation, my understanding from AWS, that we are going to finally start seeing a reduction in our rent starting with the July financials, which I, of course, haven't seen June, so I haven't seen that yet, but that's what I have been told, so excited to see what that might end up being. We were just over $3,000 is what we've been paying in rent per month. Some of in the state professional services, the shift in how we pay for IT costs, we'll continue to see that line item be a little higher because of IT costs, so that will probably even itself out with less in rent and increase in IT. That line item will probably stay similar. Year-end cost backs. This includes overhead for the Division of Regulatory Boards, including Assistant Commissioner's Office, Legal, our Centralized Complaints Division, and the Customer Service Center. The legal expenses, I've talked about this in the past couple of meetings. We've changed the way that those are allocated, and now it's per hour that they spend with our board doing something for us. So that has caused our expenses for our board to go up a bit. And so more than a bit. We are 25% higher this year than we were the prior year. So we are seeing an increase there. So I still think we're going to end the year okay. I know at the last meeting I was a little bit concerned, but things have worked out fine so far. So are there any questions? Yes.
Oh, go ahead, Todd. No. Oh, go ahead. Okay. I was just curious. Last year, it looks like we had a $50,000 hit in July. I mean, in June. Sorry, in June.
Yes.
Was that our cost backs, or was that?
Well, I have inquired about that and verified that it is accurate, but I have yet to get the detail on where it landed.
Because I just didn't know
but
if we should anticipate something like that.
Well, that's why
I figured you.
I was trying.
I knew you'd be on top
to
of
get
it.
it to the bottom of
Pay
it.
for all those software changes at one time, or did they take that out in stages? I can't remember that.
That was a one-time for our current license application. That was a $75,000 charge, but it came out of our reserves, which was nice.
Okay.
Now I do understand that we have a large list of technology items that are needed, and we understand that we are going to be able to pull some out of our reserves to pay for some of that. So we're excited about that. Now maintenance we won't be able to pull from the reserves, but for initial one-time development costs that we should be able to use that money from the reserve. So obviously there'll be a process for that, so we'll hopefully find that out soon.
Will we be able to add the little, possibly the little respond to the text if you did do that kind of, if we ever go that way, can we add that through that?
Well, we can. I mean, I can certainly look into it
Okay, I'm
and
just
see
curious.
what the vendor, have them sort out a cost on something like that. It wouldn't be, our platform is developed for all 26 boards, and so obviously I think that would be something that might be beneficial to everybody, but the cost might also be something that falls lower on the list of priority items.
Okay.
So.
On the legal expenses, what is the increment that attorneys are billing at that then get allocated to the board? Is it an hourly or a tenth?
He's addressed that before. They've come in
And
and
calling in?
I don't know what that is.
I think they do come in and try to allocate that time.
So I think the hours are submitted, and then based on if Maria's submitting the hours or the paralegal's submitting hours, the rate is different depending on who it is that's submitting the hours. You don't know?
I would hope so.
Right. I do not have it. Right. And then some of Tony's position is general hours, so we're not direct billed for that. So that falls in a different area, but I don't see the exact amount.
Who is it a general counsel for the department reviewing who reviews it, and then is it kept on when you submit, is it I've worked 20 hours this month, or I've worked, point?
Manager, and then I think
Yeah.
it goes to Toby, the assistant commissioner, to review. I mean, there are several people who review.
Right.
And are
So-
you keeping track in what increment of time? 1/10 of an hour or 10th? Okay. Part of the joys of coming to the state generally is not having to do billable hours. So I
I don't
feel
think
for
they've
you.
loved this transition.
Yeah.
I was
So-
surprised whenever I.
Yeah, just for your information, it used to be billed based on a formula, based on the number of complaints that we had, and so
This makes more sense,
Yeah.
but
yeah. So
Review those? Do you?
I do not.
That should really go. I mean,
client.
in
yeah.
my opinion, you should be reviewing that for our board.
Yeah.
That should be part of that process. I mean,
I would concur.
Okay.
I can certainly make that request. At one time, there was a discrepancy that was pretty large that I asked for the detail, and they provided it, but it hasn't been a regular thing that we have seen.
It should be routine.
But I actually think Gabe had mentioned wanting to know our costs in relation to other boards, and we haven't seen that either. So we can touch base on
Do
that.
that. Yeah.
Okay.
My only other question for longevity is kind of a legacy issue, but has some predictability there. Whereas pay for performance is going to vary a little bit on, what DOHR sets each year. If those should be separate to show a little more of, okay, pay for performance is really moving forward the status, the standard, and so the bucket that employees are receiving for their bonus there, whereas longevity is something that I would consider to be very different than
Right.
for performance. Just for I think that line item could be confusing.
So it might be a suggestion to fiscal of the department to break that out.
I think it would be more meaningful to be broken out.
Right.
More questions? Well, I will say that we've come a long way over I guess since you've been here. We're operating very, very, very efficiently as opposed to, and I think we cut our dues back, 4 or 5 years ago, and we're kind of performing back where we were before we cut it. So I think that's to be commended for that.
And I will say this, just so everybody here, maybe who has or has not been around, this has been a topic, these chargebacks, for as long as I've been on the board. But it's always been our board's fear that we're the one few reg board that has such a significant surplus and reserve, and that perhaps there's a disproportionate amount of chargebacks that come back to this board, and we've been assured by many occasions by the commissioner's office that that's not the case. So take it for whatever it is. It's a trust but don't verify type thing. But they have come down and spoken to us on many occasions because they hear us talking about that on multiple items. So
It did used to be in costbacks we got one number, and they have broken it out a little bit to try to tell us whether it's legal or whether it's centralized complaints or whether it's the assistant commissioner's office. On the net position statement, they try to break those out for you so you can see where the total, instead of a total of $300,000, you now see a little bit more detail there than we used to. So
On the longevity item, it's not worth like a huge reformatting battle, but if it could just be quantified of what the longevity component of that item is, would be meaningful.
Okay.
The last item I think we have is a proposed travel amendment to the travel budget, I guess. When do you want to talk about that and the thoughts behind it?
Yes. So another thing that this board has struggled with for many years is our travel. And so our statute does give us the option, or gives us the authority to be able to attend meetings of associations within the accounting profession. But based on policies, we have been limited at times to our travel. There is a new policy that's been adopted by the department, which recognizes our statutory authority for the board to approve travel. But what they are asking is to make sure that the board is aware and is approving the travel. So, for example, when I prepare the budget for you all to approve, I usually do that in October, and I give you a travel plan. And I usually state out the meetings and then how many people I'm proposing would go to that meeting in the budget. Okay, so I kind of took that as the board approval of our travel, and I think that's fine. But what I wanted to bring back to you was I had to reduce the 1920 travel plan based on the department only allowing us to have 3 people plus myself attend. So my request to you is if you would like to increase that by 1 person and acknowledge that you would allow 4 board members to attend these meetings, that I'd like a vote for that on the record so that when I ask for travel approval that I have the board's vote on that. Now, the first attachment has the original travel plan, and then the one behind it, I may have not done a very good job, but I went through and made some changes in red. And so I'm not changing at all the total travel expenses, but I'm just rearranging them within the travel budget itself, allowing one additional person to attend NASBA meetings. That would be 4 board members could go to a regional meeting, and 4 could go to the annual meeting in the fall rather than 3. And again, investigations have just not been costing us much of anything, so I reduced that by I think $1,000, and I still think we'll have a sufficient amount of money there. I raised the travel to the 2 NASBA meetings by $1,000. I pulled our total amount for the Eastern Regional, and we spent $79.89, so just under $8,000 for 4 board members plus myself. So I think $9,000 is reasonable for these meetings, depending on location. DC was easy to get to. The hotel wasn't cheap, but the flights were not too expensive. So it just kind of depends on flights and that type of thing. So anyway, I am asking for just a slight amendment to the travel budget so that the board, if the board's interested in allowing 4 board members to attend the NASBA meetings.
I'd like to comment on that because I've been pushing for this. I think that our involvement at the national level has dramatically increased. We have so many people involved now on different committees and whatnot. That I mean, I think 4 people going is great. I'd even be willing to allow anyone that wants to go to be able to go. But I realize we have to work within a budget at the same time. But I would make a motion that we approve what you've put together.
I would, if we're taking motions, I'd second that motion.
Oh, it'd be you. Sorry.
Okay.
Stephen, I'd like to make some comments here. I just want to re-highlight where we were 7 years ago. Okay, I just want this board to be very mindful of this travel budget, because while we have the budget for this, the reality is there's 26 rec boards under Commerce and Insurance. Whether or not they have the ability to participate in this or not, I'm not arguing the validity of travel and the importance of this travel. But please be cautious that what happens in this stuff is, and what started this, I think, in the beginning, was other boards complaining that this board was going to places and doing things that other reg boards weren't. So ultimately, we ended up losing our director, I think, at the end of the day, over this issue, because it was not that it wasn't approved at the time. It was, and it's not a problem until it is. So I want you all to understand where we were 7 years ago. This was a huge problem and a huge issue. Not discounting the validity of the travel and the need to do it. The real factor here is, and I think they may have even gone to Hawaii one year.
But the issue
So
there was it was a trip to Hawaii.
It was
totally
blew this thing up.
Yeah,
But
I mean,
it wasn't
it
just
wasn't
that.
the
It
location,
just that just magnified the situation.
You know, and I don't know what happened then. I'm glad you're giving us the
I'm
history
sensitive of it because
Yeah.
I was here when that happened.
Yeah,
so.
but I will tell you that NASBA generally has their meetings out of Nashville because it is more expensive in Nashville for them to have their functions here.
And here,
with not with the travel, but with all the other parts.
My
that
point
make
is
that up.
not to discount anything that
Yeah,
they
yeah.
do or don't do or where they have their meetings.
Mhm.
It's just we need to be mindful as one reg board of 26 that when we start spending a lot of money on travel, at some point y'all need to know that they're going to notice, and when that happens, it can be a real problem.
But I think
And it's not a
Wendy-
problem for the commissioner right now because he hasn't got anybody complaining about it. But if somebody does start to complain, there could be blowback, is all I'm telling you.
I don't think
taking the appropriate steps to find out, what do we do to make sure we're going the right direction here? What do we do to get approval? I mean, to me, these NASBA meetings that we're talking about, the regional and the annual, it's almost like CPE for this board. You go to you have classes on. I mean, we're not going to Hawaii. We're not going to resorts. We're going to.
I'm going to say this. I'm going to vote for this today, but I want fair disclosure, full disclosure from everybody here there was a period in time when the travel budget looked like this, and it was a big-time problem.
Was it 40 grand? And that was
Yeah,
a problem?
I would think it was maybe even a little more than that.
Oh,
It could have
yeah,
been.
it was closer to 80.
Yeah.
Okay. Well, I mean,
Okay,
this
that's my
just does
question.
not seem material to me. But I could be, when you look at our overall budget.
It's a relative
not-
thing. It's not whether or not it's justified or not justified.
Okay.
It's a
The other
relative
board's
thing.
travel budgets is a much different number.
Yeah.
What now? Other,
Whole lot less, yeah. And we're kind of the target.
We're different.
Right.
We're different. So,
and we have with our with our statute, we have the ability to do this. So I mean.
we can be right. I'm just saying at the end of the
Yeah,
day, you
yeah,
can be
yeah.
wrong.
Hey,
too.
yeah,
So-
yeah.
What
No,
Judy's
I hear
saying,
you.
though, is it's not,
It's
it
a
doesn't matter who
perception.
it's going travel for, whether it's anybody. It's just we were going along like this and everything on with our rules and all that, and now
And it was approved.
we've lost the director and we got
Yeah.
slack for it.
So anyways, I just say that. I want y'all to be mindful of that. I would tell you not to go outside of the continental U.S. That's another thing I would request.
We're high.
If there is a trip for NASBA that leaves the continental U.S., I would say no.
Yeah, I mean, I hear what you're saying, but from what I've been told, I wasn't on the
I
board
mean,
at that
she's
time.
put down
but I
here, it's
think-
all here, so it's not.
I think that
that's
was
not
a
an
whole different situation at that time.
Yeah, okay. Yeah, anyway.
But
I
had
can't make the
commissioner's
motion,
office
so y'all
calling me
take it.
about the issue. I mean, it was a problem, real problem.
And, to your point, that's like everywhere. Travel is going to be scrutinized.
There's a department, a
And-
major corporation, one department travels more.
Exactly, yeah,
People get
exactly.
mad.
I mean,
then they
it's
got to
not
complain
just-
about it. Guess
yeah.
what? When you complain, they don't want to hear you
And
complain.
taxpayer
And they come back
dollars
and
may
say, hey,
be-
this is a problem. I mean, that's just the
add
reality.
more. Yeah, so I
Right.
think you make a good point, and yeah, we should definitely be aware of it. But I will also say that I would think it would be a shame that if we have excess reserves that could potentially be swept away, and then this board is deprived of going to activities that benefit the education of the board and the ability of us to serve as we should be.
Cut the
But your
dues,
point
too.
is well taken.
We'll cut our dues back as well. I mean, that's
Yeah,
it.
Right.
yeah.
Comments, discussion?
We looking for a motion on this?
Yes.
I think you made a motion.
Can't.
Oh, I'll make the motion that we approve.
You can't
You
either.
can't either. It's just Trey, Gay, and Steven.
I'll make a motion that we approve the changes that have been presented to us in the travel account.
A motion on the floor. To have a second? I can
It's
second
just
it too.
the, is
I
it just,
guess.
it's just
Yeah.
the three of us, right?
And y'all the only ones that vote too, right?
Right, on this. Tomorrow you vote.
Vote tomorrow, yeah. So, all right, so I have a motion, second. Any more discussion? All in favor say aye.
Aye.
All opposed? Recommendation passes. Motion to recommend. Any other business we have? I think that's all we have for our meeting. We'll,
That's it for today.
8:30 tomorrow,
Yes,
we're adjourned.
8:30.
8:30. Oh, I'm sorry.
Gonna slink it in tomorrow.
I'm hoping to be on my way home.
Yeah, I hope to be here with you.
So are we,